which is that there are 8 justices who are deeply engaged and prepared and ask lots of hard questions of the lawyers, and Clarence Thomas never says anything. Now, even by Thomas's standards, last year was a remarkable year because there were 104 oral arguments that year, and Clarence Thomas did not ask one question in one case. An enterprising reporter from the McClatchy newspapers decided to add up all the words spoken by each of the justices in the oral arguments that year, and Stephen Breyer was first with more than 35,000 words, and Clarence Thomas was last with 0. Yet, if you see the court in action, you will see that Thomas, who sat for many years between Breyer and Kennedy, they sit in seniority order, he gets along with his colleagues. They pass notes. They laugh. They tell jokes. Thomas is not an isolated figure. They get along, and he just, for his own peculiar reasons, chooses never to talk in oral argument. But the court is a congenial place. Now, in thinking about the Rehnquist years, I think it's useful to divide the court in 2 parts: 1986 to 2000 and 2000 to 2005. And the dividing point in the history of the court, and in many respects the dividing point in the history of our country, is the court's decision in Bush v. Gore. Now, I admit to being somewhat obsessed by Bush v. Gore. I'm not going to go into a lot of detail today. There are 3 chapters in the 9 about Bush v. Gore if you're interested. As you heard, my last book before I wrote the 9 was Too Close to Call, about the recount in Florida. And one of the things I tried really hard to do in writing Too Close to Call was interview Al Gore. Obviously, he's an important person in that story. I wanted to talk to him, and he absolutely refused. I tried everything. I tried connections, I begged, I pleaded, and Gore simply didn't want to talk to me about it. And so I wrote the book without his cooperation. Just by coincidence, while I was working on the 9, I met Al Gore at a social occasion, and we were chatting, and he had read Too Close to Call, and we were talking a little about that. And I told him, you're never going to believe this, Vice President Gore, but I'm writing another book where Bush v. Gore is really at the center of it. I said, I think I may be the biggest Bush v. Gore junkie in the world. And he said to me, you may be second. Which, I think you got to give him a nod there. He really does have a bigger stake in the outcome than I did. So Bush v. Gore was decided. George Bush becomes president, and the court, this is the surprise. This was a surprise to me. This was the change. The court moves to the left. Think about all the decisions between 2000 and 2005. They struck down the death penalty for the mentally retarded. They struck down the death penalty for juvenile offenders. They decided Lawrence v. Texas, the gay sodomy case, overruling Bowers v. Hardwick, which was only from 1986. They saved affirmative action in the University of Michigan law school case, and in case after case, they rejected the Bush administration's position on Guantanamo Bay. Why? What changed? What changed was Sandra Day O'Connor. O'Connor saw George W. Bush and his Republican Party, and that was not her Republican Party. Again, the story of the change in the Republican Party. O'Connor was offended. She was a Western Republican, a Libertarian Republican, a Goldwater Republican, a Country Club Republican, not a George W. Bush Republican. She didn't like John Ashcroft. That was not her kind of Republican. She didn't like the way the war on terror was being conducted. She didn't like the war in Iraq, and above all, O'Connor was offended by an event that doesn't get talked a lot about now, but I think will loom large in the history of this decade, and that's the Terri Schiavo case. That had a big impact on Justice O'Connor, in part because, if you recall the facts of the situation, it was an attempt by Congress and the White House to sort of push the federal judiciary around, and judicial independence means a great deal to O'Connor. But even at a more personal level, the Schiavo case was about medical decision-making for a desperately ill family member, and at that moment, John O'Connor, her husband, was slipping into the grip of Alzheimer's disease. So this was far from a theoretical issue for Justice O'Connor. And during this period, 2003, John O'Connor started coming to work with O'Connor every day, with Justice O'Connor so that she could keep an eye on him. But then in 2004, he started wandering away, which is something that Alzheimer's patients sometimes do. Very dangerous, very scary. And finally, in 2005, O'Connor went to Chief Justice Rehnquist, her beloved old friend of 50 years, her law school classmate, and said, look, I have to leave to take care of John. Now, an interesting parenthetical question to ask is how many male Supreme Court justices in history would have made that decision? I don't know, but I suspect not many. But O'Connor did, and she left. And here's where the chronology becomes important and I think rather poignant, because she leaves in June '05. President Bush names John Roberts to replace her. All through that summer, the confirmation hearings are planned, but Labor Day weekend, William Rehnquist dies. Bush names Roberts to replace Rehnquist. O'Connor has to wait. Roberts has his hearings. He's confirmed. President Bush names Harriet Miers to replace Justice O'Connor. That tragicomedy takes about a month to resolve itself. And then, finally, Samuel Alito is nominated, has his hearings, and is confirmed. In all, it's nearly a year between O'Connor's announced departure from her actual departure, and during that year, John O'Connor slips completely into the grip of Alzheimer's disease and doesn't even recognize his wife anymore. So simultaneously, Sandra O'Connor loses her beloved seat on the court and her beloved husband, and the Supreme Court is now a very different place. The court is demonstrably, clearly more conservative. There are four very conservative justices, Roberts, Alito, Thomas, and Scalia, four liberal justices, Souter, Stevens, Ginsburg, and Breyer, and Justice Kennedy in the middle, usually but not always siding with the conservatives. And when you look at their decisions on abortion, on civil rights, you see that Stephen Breyer, who is hardly an extremist or an alarmist, had a point when he said in open court, it is not often in law that so few have quickly undone so much. And that brings us to the current election, because three of the four liberals are likely to leave soon. Justice Stevens is 88 years old. Now, I hasten to add, his older brother, William Stevens, is still practicing law in Florida at the age of 91, but hey, 88 is 88. Justice Ginsburg is 75. Justice Souter is 69 and really wants to go back to New Hampshire. So those are the justices who are likely to be replaced by the next president. If Barack Obama wins, I think it's safe to say that they will be replaced by justices more or less similar to them. But what about John McCain? Well, John McCain has told us what kind of justices he will appoint. Interesting, though, when he told us. And I think the Supreme Court illustrates a problem that McCain has, and it's not just limited to the Supreme Court, which is that he is a very popular, charismatic, honorable person, and that's recognized by almost everyone. But his positions on the issues are largely out of step with where the public is right now, whether it's on the economy, whether it's on the war in Iraq. It's also true about the Supreme Court. And when you see how McCain tries to finesse that, I think that tells you much. And I'd like to conclude by reading two excerpts from a speech that McCain gave on May 6th, which tells you a little bit about how he finessed what he really stands for, but let there be no mistake about what he stands for. And it's interesting, even the date he gave that speech, May 6th. That was the date of the Democratic primaries in North Carolina and Indiana. It was a day when when Obama clinched the nomination, and it was clear that McCain was trying to do it on a day when he wouldn't get a lot of attention, because his views on the law, like the economy, like the war, are somewhat outside the mainstream. Okay, here's the first excerpt. For decades now, some federal judges have taken it upon themselves to pronounce and rule on matters that were never intended to be heard in courts or decided by judges. With a presumption that would have amazed the framers of the Constitution and legal reasoning that would have mystified them, federal judges today issue rulings and opinions on policy questions that should be decided democratically. Assured of lifetime tenures, these judges show little regard for the authority of the President, the Congress, and the states.